Today we're going to talk about the top 10 things that single parents need to have in their estate plan. My name is Gregory Singleton. I'm a probate and estate planning lawyer in Minneapolis, Minnesota. I work for Signature Law, which serves the Twin Cities and greater Minnesota as well. Now, estate planning is going to be different for everyone. I've yet to meet someone that is the typical, prototypical family or have a simple estate. Estate plans depend on the circumstances of the family, their values, and their desires, and maybe their religion or other factors. One particularly crucial group that needs to have an estate plan and needs to have a comprehensive and holistic estate plan is going to be a single parent of minor children. So here are the top 10 things that single parents should have in their estate plan to make sure that they've covered all the bases. Number one is a guardianship designation. This is for when you're alive, and that's what the document's called, the Guardianship Designation. It basically says that if something happens to me and I'm incapacitated, I go into a coma or get dementia or I'm kidnapped or something along those lines, then this person, the designated guardian, gets to take over and has authority to raise these children. If you don't have the guardianship designation, your kids are going to go to social services, or a court is going to decide who gets to take care of your kids. And they may choose crazy Aunt Susan, who you really don't want to have take care of your kids. One tip is to tell people about your guardianship designations. Don't keep it secret. Tell the school, get it on file with the school. Tell your neighbors, tell your babysitter. That's a big one. When you're split from your children, you might get in a car accident that puts you in a coma. Tell family members, tell close family members, make it known. Otherwise, your guardianship designation is not going to do very much good if no one can find it and no one knows about it. Number two, guardianship designation for when you're dead. This is usually a provision in a will that says when I die, if my children are still minors, then they will be raised by Bob and Susan. And if Bob and Susan can't do it, then it will be Jack and Jill. If you have a Revocable Living Trust, you're still going to put the guardianship designation in your will. It's just going to be in the pour-over will, which is kind of a catch-all will, which whatever you forgot to put in your trust is going to be pulled into your trust. It'll also have a provision for guardianship designation. The third document you need to have is a healthcare directive. Now, this is important. In Minnesota, our healthcare directives are two things. They are the medical power of attorney and the living will. The medical power of attorney gives someone authority to make healthcare decisions. The living will tells people what those decisions should be. Now, if you're a single parent, you don't have a spouse. And your kids cannot and really should not be trying to make life or death decisions about you when you are incapacitated. That's just not fair to the kids. If you have a partner or if you have parents or family or a good friend, someone needs to be designated as their healthcare agent that can make those decisions for you. The number four, the durable power of attorney. And this is similar to the healthcare directive in that you need someone to be able to take care of your finances if you become incapacitated. This is important because whoever is designated as your guardian may need access to extra funds to raise your kids while you're incapacitated. You don't want to burden someone with your children who just financially can't afford having your kids. So having a financial power of attorney, a durable financial power of attorney, can help this out. Number five, Revocable Living Trust. Now, I'm not going to go into detail what a Revocable Living Trust is. We're going to do that in a different video. But I will say that there are trust lawyers out there that want everyone to be in a Revocable Living Trust. I see myself more as an estate planning attorney, and where sometimes Revocable Living Trusts are appropriate, sometimes they're not, you just need a will. But in the case of a single parent, I usually recommend that people have a Revocable Living Trust. And the reason for this is the Revocable Living Trust will avoid probate. Your guardian of your children after you die is going to need funds to raise your kids. And when you go into probate, all your assets are frozen. And when your assets are frozen, your guardian can't access those assets until probate is over, which may be 6 months or even 2 years down the line. You want to make sure that your guardian has the funds to raise your kids appropriately so that they can move on and they can be raised well. They need the money now to make that change, not 18 months down the road. Number 6, a testamentary trust. Again, this is something that we're going to have a separate video on. And it's not a separate document. The testamentary trust is a trust that's placed in a will, and when your will goes into effect when you die, the testamentary trust comes into effect. There's a couple reasons that you may want to have this. Is you may want to leave money to your children. If you don't put it in a trust, it may be all used just to raise your children, and there'll be nothing left when your child turns, say, 21, when you want them to have it. You may want to put some money aside just to restrict it to education. Say, if you choose to go to college or grad school, this money is for you. You can also take money and put it in a trust and just restrict it to supporting your children for health, education, maintenance, support, the HEMS standard, so that if the guardian of your children can't use the money for, say, a big vacation, they have to use it for raising your child. Number 7, life insurance. Now, I don't sell life insurance, but life insurance is a big part of estate plans. If you have minor children, it's very likely you haven't fully funded your retirement account yet. That usually happens in the years after you have your children. So a life insurance can bridge that gap. Secondly, you can also do a split strategy. You can have, for instance, a retirement account and investment account go to your child's inheritance, something they'll get when they're 21 or 30 or something down the road. But the life insurance will be around to immediately fund raising your children. That way you wouldn't have to have a revocable living trust. You could do it with just a will, but the life insurance is there for immediate access. You also, in this case, might want to use what's called an ILIT, an irrevocable life insurance trust, where you can take the life insurance, put it in a trust, and restrict the use of that money in the trust just for health maintenance, education, and support. Number 8, letters of the estate. Now, no one else calls it this. This is my term, but I like it. Letters of the estate. What this is a letter that's not officially part of an estate plan per se, but you give your final thoughts to your children and your family. It gives your kids closure. Say, hey, Johnny, Daddy's died somehow. I'm not sure how. I love you very much. I hope for the best for you. You have all the potential, all that jazz. It's a great way to give closure to the child that they may not have otherwise in a very personal way. Something else you can do, and I'll talk about this in a video that's all on letters of the estate, but you can make multiple letters. And you have, for instance, one for when you die. Then you have a letter that they're given upon high school graduation that says, hey, congratulations for graduating high school. Here's a couple thoughts. You can have one for when they get married. You can have one when they have their first child, etc. You can have a whole series of letters for special occasions, or first Christmas without you, that will really be meaningful after you've passed. Number 9, a letter regarding your family medical history. Now, it's important to know your family medical history. You know that Uncle Jack had cancer and Aunt Susan had diabetes. But more importantly, usually people go to their parents to find out what their medical history is, and they don't think about it until they need it. After you're gone, they can't go and talk to you and get a medical history for you. So having a letter included in your estate plan that includes your family's medical history can be a big help to your kids down the road. And number 10, finally, talk with your kids. When they're old enough, sit down and have a talk. It's a hard talk to have with them, but make sure that they understand that there will always be someone there to care for them, that they're going to be financially taken care of, that who their guardian is going to be, And this is just in case of an emergency, but it's all information that they should know. When they're old enough, let them in on this situation and on your estate plan, so that they know and they can be part of everything. So there you have it, the top 10 things that single people need to have in their estate plan. My name's Gregory Singleton. I'm with Signature Law. If you liked this video, please feel free to hit the like and subscribe button below. But until next time, Gregory Singleton with Signature Law.